why is it that in the same types of cases, you line up a whole crew of trial lawyers from around your cities, around your state, around the country, and they have similar evidence in the cases, and yet there's a group here that continues to get extraordinary verdicts, like a 2-level cervical fusion in a minimal impact collision, and one lawyer getting verdicts of $6.8 million, $8.8 million, and even recently $22 million. While in a same identical case, a group of lawyers over here are getting $200,000, $210,000, $190,000, 0 findings of no permanency. What is that all about? I believe the biggest part that that's all about is your mindset, your attitude, and it has to do with preparation. One lawyer prepares for a deposition of an accident reconstruction which is going to take place Monday in this way. On Sunday afternoon, that lawyer is sending emails to other lawyers in the firm. Anybody got an outline of an accident reconstruction expert? And they're scrambling to put together quick questions and just going to go through the motions. What do you do as an accident reconstruction expert? What is this on impact? And what is this formula? And how does that? And just going through the questions. Another lawyer who I know, named Dustin Herman in Cleveland, Ohio, that deposition that's happening Monday, he's been going insane getting ready for it for 90 days. And then he whittles it all down. And when he comes out of the deposition, he goes, I crushed it. Because all of a sudden they want to settle because, yes, they admitted that their expert was wrong, or they admitted to this, they admitted to that. So to me, that has so much to do with it. Yet when we look at, let me pop this back on the screen there. Let me get the yellow back up there. Here. Redirect examination, these 4 areas, plaintiff's case and rebuttal, preparation of the jury instructions and verdict form, and what goes into the deliberation room. These are the most abused area of trial lawyering when it comes to these jury trials. Lawyers don't pay attention to them. They don't think about them. They set them aside. You say, well, what do you mean set them aside? The jury instructions were due a month ago. Oh, yeah. I know what most firms do with jury instructions. Hey, anybody got a set of the standard instructions in an auto case? Yeah, can we put them together? Yeah. How about the verdict form? Yeah, we put the verdict form together. I still get proposed verdict forms from defense lawyers. We just got one a few days ago. And the first question reads, do you find negligence on the part of the defendant driver, which was the cause of loss, injury, or damage to the plaintiff? And yet our law says it's not the cause, it's supposed to be a cause. Even our standard jury instruction, Dino, in Florida says a cause. You go, how is that happening? The reason it happens is they're simply trying to sneak in one word. Well, if they get to argue the cause, here's the verdict form, ladies and gentlemen, that can spin that case. What lawyer do you know, you don't need to put your hands up, sits down and as you're preparing for trial, prepares for redirect? I can give you the answer, almost 0. You prepare for direct examination. You prepare your client for cross. Nobody's doing that when it comes to redirect. How many lawyers sit down and go, what are they going to take into the jury room with them? I'll give you the answer. Of all the lawyers at this conference, maybe 5. Even think about it. Most lawyers, you are scrambling at the end. Get the jury instructions, get the verdict form, and you have summations. And then the judge says, all right, well, what do we send him back with the jury? Judge, it's all the exhibits and evidence. Well, wait a minute. Do demonstrative aids go back or not? Around the country, including in Florida, it depends on your judge. I have many judges who say yes, many judges say no, it's only a demonstrative aid, which is why I try to get them put into evidence as exhibits. Some judges say yes, some say no. What if there was a model that was built? What happens when the jury sends out a question? We would like to see the model in the jury room. You know what the defense is going to say. We don't want them to see the model. We don't want that. So you've got to be thinking about these things.
Oh my God. I want a case. Jesus Christ. We won. I won. Yeah. I'm the law, bitches. I'm a lawyer.
Okay. You don't want to be that lawyer when you win. It's kind of like in sports. It's rather unusual, the celebrations I have seen over the years. But at least what I was taught is that in most situations, a coach will say, act like you've been there before, okay? And that's in sports and in the courtroom. So, purpose of redirect, clarify anything that's now confusing. Confusion, vagueness, cloudiness favors the defense. Just like if I'm doing a criminal defense case, well, I want confusion, I want cloudiness, I want things to be vague, because then they're not going to get beyond that burden as to a reasonable doubt. Rectify errors or mistake. Don't sit back and go, well, that's no big deal, I don't want to touch it because it might open a can of worms. Don't be afraid of that. If your client made a mistake and it's easily brought to their attention, you do that, okay? If a witness makes a mistake. I represented years ago the young lady who who was both Cinderella and oh my goodness, Little Red Riding Hood at Disney World in the parades, and it depended on what time of year it was. She had been Miss Dance in South Carolina. She had been a gymnast. She was a great athlete, and she was a great dancer, and that's how she got this position down at Disney World. One day, she's on the back of a motorcycle. Her cousin's riding. They get hit by a car that runs a stop sign. She has a knee injury. After the knee injury, I send her back to her teacher and coach to evaluate her so that the teacher and coach can come in front of the jury and explain the difference before and after, how she can't dance now, can't make the same moves, etc. So she's on the witness stand, she does a good job. Then they cross-examine her, and it was her right knee. And the defense lawyer starts asking questions. So now I understand when she had her left knee there and you saw it, there were problems with it. There were problems with it. I'm sitting there. At first I object, and the judge says, come on up, and he goes, you let him go. If something needs to be clarified, you can clarify. He probably asked 10 questions where she says it all had to do with the left knee, not the right knee. Do you think you can leave that alone when the whole case is about the right knee? You can't. So you come back on redirect. Ma'am, I'd like to ask you to think hard. I know you asked a number of questions about which knee it wasn't. Just looking at her. When you're looking at her, which knee was it? Well, she was facing me. It was the knee. It was the knee on the left, but it was her right knee. I'm sorry. I made a mistake. She clarifies it. Sometimes it's easy to clarify, sometimes not. Rehabilitate the witness and retake the high road or the mow. You don't want a defense lawyer to cross-examine one of your witnesses, and then all of a sudden, it's like the defense now has a train going down a track. Stop that train as quickly as you can with an important area on redirect. The cross please understand this, is 100% predictable. If you are prepared, you know what the cross is going to be. You're going to do an OSPA, O-S-P-A, opposition strategy prediction assessment on every aspect of the trial. When you do that, you go, if I were the defense lawyer, what would I do to cross-examine this witness? The other thing is we got a trial coming up that Jessica and I are going to try in a few weeks. Jessica, hold your hand up there so everybody can see Jessica. Right here. And Jessica and I, what we've been doing is Jessica's been gathering the transcripts of the defense lawyer from several trials, post-COVID trials that he has had, so that we know his voir dire, his opening statement. We've got the transcripts. You might think this is shocking. It's not shocking to me. In every case, his cross of the main plaintiff doctor, his cross of the plaintiff, he's operating off the same outline he must use in every single case, and then there are a few variables. So it's predictable. Dino, comments? Yeah.
Is going to be in large part on whether, and John touched on it, whether you've properly prepared your witness. Because John's exactly right. 98% of the questions that the defense is going to ask, you should know and have prepared the witness for. Now, if the witness makes a mistake and screws up, you can't do, there's not a lot you can do with that. But you have to actually role play with those witnesses in preparation, especially your plaintiff and your experts, who you have control over more so than maybe a treating physician. So if your client is going to be cross-examined on their history of back problems, let's say, or a prior injury of some sort, you need to role play with them long before they get on the witness stand about here's what's going to happen, and they're going to use this medical record, and they're going to use this piece of paper and this document, so that you don't have to, so that they're prepared to answer that question. And instead of saying just yes and no in their answers to the cross-examination, they need to be able to say, yes, I had a back injury for a long time, but I was treated, I was fine. I hadn't seen a doctor in 10 years. Not just, did you have a back injury before this accident? Yes. Well, shit, that's a whole different answer than I just gave you. The answer needs to be, and they need to be prepped on that yes, I did, but I hadn't been treated in 2 or 3 years or 10 years or whatever it was. So that they can respond, so that hopefully limits the extent of your redirect examination. I think the other piece of redirect is you want to end that witness on a high note. I think that's important. So even if there is nothing big in redirect, I still think you need to be prepared to have one final question that's a good answer, a good question and a good answer for you, so when the witness is done, the jury is left with a final good impression of that witness. I think that's very important.
Oh my God.
No, I don't know
What happened to our
why
thing?
it goes back to that, but we'll find out. I don't know.
We've had all kinds of consultants try to.
Effect in there. I was trying to make it dramatic for a purpose, because I wanted to make a point, and I said, well, can we put like an explosion sound in there? And we couldn't figure out how to make the sound at the right time. All right. There we go.
The amount of work that went into that is an amazing, ridiculous story.
All right. Dino.
Yes.
Why do we not want to cover too many points in redirect?
If you ever listen to Joe Freed, he talks about a speed trial. This jury does not want to hear the whole direct testimony again. They want 2 or 3. Remember, there's the rule of threes. You don't ever have more than 3 points, right? Rule of threes. So, boom, 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 sit down, shut up. And that last third point needs to be a strong one for you. Needs to be a strong one. One of the hardest things, though, and I think we need to maybe have a conversation about this, is what do you do when your client or your expert, for example, gets impeached with their deposition or some document. That is always a struggle because you're sitting there and you're thinking at counsel table, oh no, they said this, they said they didn't have any back injury, and now there's a document that says that they had a back injury before this. And so, or maybe they testified to something that's been contradicted from their deposition. I think that's one of the hardest things to cover. And as I say, if you prepared your client properly to begin with, you should not be in a position of having to fix a contradiction, okay? But to say it never happens is, we know it does, all right? Given everybody's best efforts. But oftentimes it's because the lawyer hasn't dotted all the I's and crossed all the T's, right? But you need your clients and your experts to testify to exactly what was said in the deposition. Because it's so hard then in redirect and say, you know, can you go to page 36 and line 17 and we go back over it and when it's all said and done, no one knows what the hell happened. Okay? The only thing they do know is that this guy has not told the truth. But get in and get out.
I have maintained over the years that there's a crossover as to whether you're trying an eminent domain case, personal injury, first-degree murder, breach of a promissory note. If you're a good lawyer and you can cross-examine experts, you can do it in virtually any type of a case. So several years ago, I'm representing a man who is allegedly a member of the Greek mafia. I say allegedly because I often hear about the Italian mafia, and of course, we know there's no such thing, right? Okay. This guy's charged with solicitation to commit first-degree murder or murder for hire. And when I get a call from his mother, and she says, my boy is in jail, and I'd like you to represent him. I said, where's he in jail? She says, Bergen County, New Jersey, in Fort Lee, New Jersey. And she tells me he's charged with murder for hire. And I said, what's he doing up there if the case is down here? Well, he was convicted. And on the day of his sentencing, he escaped. And the FBI recently caught up with him and he's in jail. I said, well, I'll fly up there and meet with him, but I'm not making a decision yet. So I go up there, I meet with him, and then I was convinced of one thing, in spite of everything else that I learned about him, okay? I felt that as to this particular crime, not only was he not guilty, he was just totally innocent. So we have to file what is called a 3.850 motion. And this is a motion to void, vacate, do away with a conviction based on ineffective assistance of counsel. When you do a case like that, you're basically trying a legal malpractice case. And you have to prove substandard lawyering, number one. And number two, under a U.S. Supreme Court case, you have to prove with a good lawyer doing the right things, it would have made a difference in the outcome. Okay? By the way, just as an aside, one of the things we did in that case, I did 3 mock trials using all of the things that we did that first lawyer didn't do. Not guilty, not guilty, not guilty. Had Dr. Melissa Pygott, who was our trial consultant, do an affidavit, and we submitted the affidavit in support of the motion. During that trial, I call our client to the stand. And by the way, I've gone to verdict in about maybe 40 criminal cases. In every single criminal case I ever tried, I put my client on the stand. Some people may say, wow. Because to me, it was a matter of they're guilty or they're innocent. And I'm not going to get into the technicalities of the law. That's what I wanted to prove. So as we're trying that case, after I'm done, the prosecutor goes and just goes to town, cross-examining, well, isn't that you on video? Saying, all kinds of bad things. And then he says, no more questions. The redirect was this. I said to the client, his name was Bill Maxicools. I said, Bill, on your feet, please. And he stands up. And I said, I'd like you to turn over here. I'm going to ask you a question. Did you ever pay anybody any money with the intent to have anybody hurt or killed? Say it. And he said, no. I said, I'm done. They wanted recross. The judge said no. Sometimes in a case, that's the redirect. You do something more dramatic.
And he ended on a strong point, right? Yes. The strongest point of the whole case.
Yes.
So you get a good, strong question, a good, straightforward, strong answer, and you sit down. And it's huge, huge.
Yeah. And you say, well, did you just think about that? No, we didn't just think about it. We prepared for that. We knew that was likely going to happen. I've done it in a number of cases over the years where that's what we do. The redirect is, look the jurors in the eyes, and I'm going to ask you one question. Tell them. There's nothing more important to jurors than hearing it from people. And it can be so important.
Well, and the other thing is, at the end of the day, especially if you're dealing with your client, whether it's a criminal case or civil case, the credibility of that client is everything. It's absolutely everything. If they like and believe your client, you got a pretty good shot at winning that case. If they don't like and believe your client, I don't care what the evidence is. You're screwed. You just are. And so if you're going to do something on redirect, you feel like you have to, it has to be something that builds your client's credibility or restores it.
I take pride in doing my own keynote presentations and putting them together, but I asked the team to assist me today. And we had a lot of fun, and we really did. It was crazy trying to put it all together. All right. The law. The law is going to vary state to state, but remember, generally you have to stick to whatever came out on cross, and the witness should be able to explain to that. I'm not going to go through this. I want to skip through this. These slides are available. All you got to do, you send us an email, and we'll send you these slides. But I want to skip through this. Plan ahead. Did they land a punch? Weigh the risk. I usually, I can't think of a time when I've not done redirect, unless it's like a records custodian type of a witness. But if it's my client, if it's an important expert, take an economist. An economist, you know exactly what they're going to do to cross-examine, and you work out in advance because you talk to your economist and you go through, okay, here's where we're going on redirect because here's what they're going to do on cross. You can look at the transcripts of the defense lawyer from other cases. They do the same thing all the time. It's so predictable. The most important one here is be brief and get to the point. And for those of you who saw the movie Karate Kid, you remember Mr. Miyagi said to him, wax on, wax off, wax on, wax off. I say, get in, get out. Most cross-examinations that I do last maybe 15 minutes. A redirect is generally going to be short. I want to hit home an important point. And although it is true you're not supposed to lead on redirect, I can't explain this one, Dino, but no leading on direct. I then get up, the defense lawyer gets up, does cross. For whatever reason, I start leading like crazy on redirect, and there are no objections.
And the judge allows it too.
And it's almost like, I can't even, it's surreal. But you say, now you understood before he asked you this, that's true. Yes, that's true. And you would agree that, and the there's no objection. It's like it's another world.
Well,
not always.
I think the reason it's allowed, just from a practical point of view, is you kind of have to set the stage for why you're asking the question, right? Mr. Smith here asked you in your cross-examination whether the light was green, and you said it was, and you have to ask that preparatory question before you can finally get back to the question that you really want to ask is, was that true, or how come you said this? So I think it's probably why, but I think you lead until they don't let you lead.
All right. Some good books you want to take a look at. These have to do with persuasion, with ideas, with decision making. Made to Stick. What do you say when it sticks? Very important. The movie Blink. Everybody who's read the movie Blink, we know this. If that back door opens, and let's just say someone sticks her head in the window and just says, "Is this room number 5?" We say no, sorry, and she ducks back. Each and every one of us who turned around and looked at her, our subconscious made over 300 judgments about her, whether she's smart, not smart, healthy, unhealthy, mean and nasty, nice and sweet. Unbelievable. Okay, the whole concept, love at first sight, those types of things we hear about. Read the book Blink. When you're in the courtroom and the jurors are downstairs, and the judge says, "All right, we all set? We ready? Can we bring the jury up?" Yeah, they bring the panel up. Remember this. When each juror comes through the door and they're looking quickly to see what's going on in the courtroom, and they see you, bam, 300 judgments were just made in their subconscious. So if you're over in the corner high-fiving it with somebody who's in the courtroom, judgments are being made. If you're sitting down and you're writing, paying no attention to them, judgments are being made. If you're sitting in the most dorky pose I've ever seen lawyers do, this one, it is amazing to me that lawyers do that. Wouldn't you agree, Dr. Smith? I go, what is that? I don't know what that is. Get away from folding your arm, especially males. With the female, it's different. I've seen Liz Weibel do it. I don't know, it's wonderful, the way she does it. But for most men that I know, it's ridiculous. They're making judgments. So when they're coming through the door, our team, we tell them always, you're standing with your hands at your side and you're just looking at them. You're not staring at them, you're not glaring at them, but you're looking at them. If they nod at you, you can nod at them, and you're trying to size them up, they're sizing you up. Remember, persuasion begins in the parking lot, really meaning the first time people are laying eyes on one another, that's when they're making all these judgments. By the time you get done with opening statement, the judgments are long gone. They already got you figured out for what you are and what you're not. Then there's going to be more to it, because that night they're going home and they're going to look up every one of you on the internet. And if you have an ad on the internet and it says, "We handle cases, and by the way, we don't care if it's your fault," that's not good to have on your website.
You know, and you need to tell your witnesses that, because your witnesses are going to be going to lunch at the same places these folks are going to go to lunch, parking garages, all that kind of thing. So John's exactly right. They're making judgments right then and there.
Culture Code, another one. You see these books? All of them. There's so many, you know there are. Thinking Fast and Slow is another one. There's one called Empathy in the Office. That's a newer book. You want to read these books and see what these things are all about. All right. Next area. Dino, you want to touch on this?
Yeah.
Actually, the plaintiff's case and rebuttal.
Yes. So a lot of times we might save a witness, okay, for rebuttal, because we want not only the first word, because we get to go first in the case, but we also want the last word.